There is simply no good reason to not resolve this conflict now. Preach! Despite the clarity of the legal issue and the dire need for an answer from this court, 6 justices refused to recognize the rights that EMTALA protects. The majority opts instead to dismiss these cases, but storm clouds loom ahead. 3 justices suggest, at least in this context, that states have the free rein to nullify federal law. 3 more decline to disagree with those dissenters on the merits. The latter group offers only murmurs that petitioners have raised a difficult and consequential argument about Congress's authority under the spending clause. So as of today, the court has not adopted Idaho's far-fetched theories, but it has not rejected them either. Instead, the court put off the decision. But how long must pregnant patients wait for an answer? Until we confront the pending petition that the government filed with us after the Fifth Circuit enabled Texas' flouting of EMTALA, until these very cases return to us in a few years, will this court have a do-over, rehearing, and rehashing of the same arguments we are considering now, just at a comparatively more convenient point in time? Or maybe will we keep putting on this issue together, allowing chaos to reign with whenever lower courts enable states to flagrantly undercut federal law, facilitating the suffering of people in need of urgent medical treatment? Justice Alito wishes he was this smart. Justice Alito wishes he could write opinions this well. If you're leaving, Nick Rich, good to see you. Thank you. Blue mega tsunami coming in November. Hopefully this bullshit will be enough to get people off their asses and stop being so like, oh, Biden's too old. F you. Trump is also old. It shouldn't be on the table. So to be clear, today's decision is not a victory for pregnant patients in Idaho. It's a delay while the court dawdles and the country waits. Pregnant people experiencing emergency medical conditions remain in a precarious position. And that's true, because right now you're only dealing with Idaho and Idaho's stay. What about the patients in other areas where EMTALA is, conflicting with state law? What then? We need more Ketanji Brown Jacksons on the court. A court of 9 Ketanji Brown Jacksons would be awesome. Just clone her. Justice Alito. Here we go. Here comes what is likely to be poorly written drivel, with whom Justice Thomas joins, and with whom Justice Gorsuch joins as to parts 1 and 2, dissenting. Whisper Mason. EMTALA sounds like it's a great middle name. John EMTALA Slocum. Or Slocum. I still just want to keep wanting to sing the song. EMTALA, you don't stand me, snowby, I go blam. These cases, this is Justice Alito speaking now. This case presents an important and unsettled question in federal statutory law, whether the Emergency Medical Treatment and Labor Act, EMTALA, sometimes demands that hospitals perform abortions and therefore preempts Idaho's recently developed Defense of Life Act. Enacted 40 years ago, EMTALA requires hospitals, we know what they do. After this court's decision in Dobbs v. Jackson, Idaho and other states enacted new laws restricting performance of abortions to protect both maternal health and safety. Is that what he really thinks? Do you really think that these laws in Texas and Louisiana and Ohio, before they did the voter constitutional amendment, protect women's health and safety? You're already at peak dumbassery right there, Alito. Jesus. Again, how dumb can you be and be on the court? Take a shot every time Justice Alito says something dumb. You'll die of alcohol poisoning. Idaho's law permits an abortion only when necessary to prevent the death of a pregnant woman. Shortly before Idaho's law took effect, President Biden instructed members of administration to find ways to limit Dobbs' reach. Protecting access to reproductive health care services, Executive Order 14076. In response, government lawyers hit upon the novel argument that under EMTALA, all Medicare-funded hospitals, that is, the vast majority of hospitals, must perform abortions on request when the health of a pregnant woman is in serious jeopardy. Okay. I don't know why that's novel, but okay. In the government's view, EMTALA trumps laws like Idaho's, which allow abortions to only preserve life in the life of the pregnant woman. That's correct. That is correct, and that's what the government stance is. The government sued Idaho on this preemption theory that obtained a preliminary injunction against enforcement of state law to the extent that it conflicts with EMTALA. The government's preemption theory is plainly unsound. Oh, is it? really, mister, I don't understand the Constitution or know that the Ninth Amendment exists. Far from requiring hospitals to perform abortions, EMTALA text unambiguously demands that Medicare-funded hospitals protect the health of both pregnant women and her unborn child. Oh, yeah, we know. We saw earlier how, Kagan showed how Alito wanted to take things out of context. Because you're a moron, Alito! Even if there was some ambiguity in the statutory text, we will be obligated to resolve that ambiguity in favor of the state because EMTALA was enacted under the spending clause, and have held time and time again conditions attached to receipt of federal funds must be unambiguous. It's not unambiguous, though. You must be able to protect the patient's health. If you're not protecting the patient's health, you're not following the law. That's unambiguous. Here, no one who has any respect for statutory language can plausibly say that the government's interpretation is unambiguously correct. I do, as do some of your colleagues, as do most people with reading comprehension levels above 3rd grade. Maybe I'm being too insulting to the 2nd graders, I don't know. And in any event, Idaho never consented to any conditions imposed by EMTALA, and certainly did not surrender control of the practice of medicine and the regulation of abortions within its territory. You don't have to consent. The Supremacy Clause, bitches! Am I going to have to say this over and over again? Like the last time when I was going over a Supreme Court ruling and I kept saying 10th Amendment, bitches? Supremacy Clause, bitches! Recognizing the flaws in the government's theory, no. And Idaho's strong likelihood of success, no. This court stayed the preliminary injunction pending an appeal, and wisely or not, the court also took the unusual step in granting cert before Idaho's appeal was heard before the Ninth Circuit. This court's Rule 11. Now the court dismisses the writ, and what is worse, vacates the stay. It's terrible! Cry about it. The about face is baffling. Well, maybe it's baffling to people who don't, are not good law people. It's probably what you call it. They're law people. Nothing legally relevant has occurred since January 5th, and the underlying issue in this case, I think they described earlier in the ruling, Barrett seemed to actually explain what the difference was and why there's a narrowing between the cases, and that's probably why the conservatives said, okay, we can kick it back now. The underlying issue with the case whether EMTALA requires hospitals to perform abortions in some circumstances is a straightforward question of statutory interpretation. It is squarely presented by the decision below, and it has been exhaustively briefed and argued. So he's almost, in some point, agreeing with Justice Jackson with the fact that they've argued the cases already, let's just decide it. It's just they're on completely opposite sides of the world when it comes to what they actually think the outcome should be. In addition to these parties' briefs, we received 46 amicus briefs submitted by 44 states, District of Columbia, briefs expressing the views of 379 members of Congress, briefs from prominent medical organizations. Altogether, we have more than 1,300 pages of briefing to assist us, and we've heard nearly 2 hours of argument. Everything there is to say about the statutory interpretation question has probably been said so many times over. The question is ripe for decision and as ever will be. Apparently, the court has simply lost the will to decide the easy but emotionally and high politicized questions that the case presents. That is regrettable. Having already taken the extraordinary step of granting cert before judgment, we have no good reason to change course now. This is especially so because the court decision to re-examine the stay issued in January makes it necessary to reassess whether Idaho showed likelihood of success on merits, a question that is closely related to the question of if Idaho and the government has correctly interpreted EMTALA. I will therefore proceed to analyze what EMTALA means. Oh, I'm sure this will be good. The text of EMTALA shows clearly that it does not require hospitals to perform abortions in violation of Idaho law. Wrong. Sorry, you're wrong. The contrary, EMTALA obligates Medicare-funded hospitals to treat, not abort, an unborn child. No. EMTALA requires hospitals to treat an unborn child in the case where a person who's pregnant comes in and says, I'm having an issue with my pregnancy. I'm not at risk, but the fetus is. Treat the fetus. EMTALA is now required of hospitals to treat the fetus. It does not stop the requirement to treat the pregnant person and stabilize the condition, including an abortion, if that's what's needed. EMTALA imposes two main obligations on covered hospitals. First, a hospital must, within its capabilities, screen any individual arriving in an emergency room without regard to individual's ability to pay. The purpose of the screening is to determine whether an individual has an emergency medical condition, which EMTALA defines as follows: a medical condition manifesting itself by acute symptoms of sufficient severity, such as the absence of immediate medical attention, could reasonably expect to result in 1. Placing the health of the individual in serious jeopardy, serious impairment of bodily functions, or serious dysfunction of any bodily organ or part. When the hospital determines that an emergency medical condition exists, it has two options. It may provide treatment within its capability of staff and facilities, or it may transfer the individual. As no point in the elaboration of the screening, stabilization, and transfer requirements has EMTALA mentioned the word abortion. And as we remember with the Ninth Amendment argument that Alito seems to forget, Alito seems to have forgotten the Ninth Amendment when it comes to the Constitution, that the enumeration of the Constitution certain rights should not be construed to deny or disparage others retained by the people. When he was going over Dobbs v. Jackson, he doesn't quite understand the fact that it doesn't have to list all of the particular conditions. Because if you required EMTALA, this is why Justice Alito is so dumb. This is why he's so dumb. If you required EMTALA to list every single possible condition that is required to be treated, you're going to miss one. You'll miss several. In which case, you leave it up to the doctors to decide. You don't leave it up to the people who draft the legislation and be like, oh, well, this one should be included and this one should be included. No. If the person's health is at risk, the emergency room is required to treat the patient. Period. That's the unambiguity. You don't have to mention abortion in order for abortion to be included in the procedures that must be performed. You dumb piece of crap, Justice Alito. Justice Alito is a dumb piece of crap. That's what this video should be called. Justice Alito is a dumb piece of crap. See, just the opposite is true. EMTALA requires the hospital at every stage to protect an unborn child. No, that's not true. Not at all. Begin with the screening provision, which hospital is to determine whether or not an emergency condition, blah, 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 blah. Thus, if the hospital identifies an emergency medical condition threatening the child, it must stabilize that condition in order to ensure that the child's health does not remain in jeopardy. Yes, and that's only pertaining to that particular condition, because hospitals were not doing that, so they had to mention it. It's the whole, like, it's the same thing about, like, why you need the Bill of Rights and the Ninth Amendment. Roll back history lesson. When they were debating whether or not to have the Bill of Rights, you had people who were like, it's terrible, we should never have to list the rights, because if you list the rights, people are going to say this is the only rights that people have. And that's it, because here's the list. We've listed them right here. Bill of Rights. They're right here. We don't have any more that are guaranteed rights, because these are the rights. So why would we list them if we were just going to limit them? Because people are going to argue that they're limited. So the compromise is to having the Bill of Rights to protect things like speech and religion and bearing arms and not being forced to, testify against yourself, was to have the Ninth Amendment. So that nobody could make the argument in an educated way, at least, that says that just because something isn't listed as a right, it doesn't mean it's not a right. But dumbasses like Alito still do it anyway. So they had to go ahead, but because people were considering issues with, I guess, the fetus as not being issues with the patient, and therefore weren't treating them in emergency rooms, government was like, all right, well, we need to carve this out and basically make sure that y'all know, look, this is one example, but it's not an exhaustive example, and it's only an example in the case where the fetus is having an issue. It's not, you must protect the fetus at all times, even if to the detriment of the patient's health carrying the fetus. Whisper Mason, you were close. Scalito is only when Scalia and Alito combine to form the lower torso. It takes all 9 SCOTUS spacecraft to combine and form Voltron. Yeah, but see, something actually came up in my Facebook memories recently where I basically said that Alito is like Scalia from Wish. That actually came up in my Facebook memories recently. So I used to call Alito Scalito because he wanted to be Justice Scalia so bad. He just lacked the mental capacity to be Scalia. This is not to say that I agree with Scalia. This is not to say that I support Scalia. But even when Scalia wrote an argument, as much as you might have wanted to disagree with it, you couldn't sit here and say this is a dumb ruling. He wouldn't miss things in the he wouldn't be like, I don't think Scalia has ever made the argument that just because abortion's not a right because it's not listening. I could be wrong about that, but Scalia, when he wrote arguments, they were well written. They might have been crappy arguments. I might have still disagreed with them, but they were at least well written. You could understand them. They made sense. Again, most of them I disagreed with, but at least I could read them and go, oh, this wasn't written by a fourth grader. Apologies to any fourth graders who might be listening. Let's see. Similarly, if a hospital wants to transfer a pregnant woman to another facility, it may do so unless other things the physician certifies that directly through an intermediary that the medical benefits of transfer outweigh any increased risks. Blah, blah, blah. The government struggles mightily, but unsuccessfully, to get around the language. First, the government argues that EMTALA's repeated use of the term individual coupled with the dictionary's active definition of what the term is does not include an unborn child, shows that all EMTALA duties, screening, stabilization, and transfer run to the individual seeking care. The assertion falls flat on its face. In light of EMTALA's express protection for the unborn child. Besides, there is simple explanation for EMTALA's repeated use of the term individual. It provides no support for the government's interpretation. Most of those references involved conduct in which only the pregnant woman can engage, such as going to emergency room, receiving medical condition, consenting to refusing treatment, or filing suit. Many references concern transfer to another facility, blah, blah, blah. Second, based on the provision stating that the individual may not be treated without consent, the government infers that it is the pregnant woman, not state law, to decide how to proceed when her health is at risk. The government logic is faulty, says the dumbass Alito, whose faulty logic reigns supreme. Literally. The right to withhold consent does not necessarily carry with the right to demand whatever cannot be done without consent. What? The right to withhold consent does not necessarily carry with it the right to demand whatever cannot be done without consent. X may withhold consent to contract with Y, but that does not mean X may demand to enter into such a contract. A person may not be forced to assume the duties of the presidency without consent. It does not follow that this person may be demand to be sworn in as president. Wow. How did he come up with that garbage? That's awful. Ugh. I'm not going to say that's his worst argument that he's ever made, but it's top 10. Or to provide an example that is more clearly related to the matter at hand. Okay. The right to refuse medical treatment without consent does not entail the right to demand treatment that is prohibited by law. Cancer patients have the right to refuse treatment that doctors recommend. They do not have the right to obtain whatever treatment they want, such as administration of a drug that cannot be legally used in this country. Likewise here, a woman's right to withhold consent to treatment related to her pregnancy does not mean she can demand an abortion. Except EMTALA says it does. And the state does not have the right or the authority, the state does not have the authority to criminalize an act that is required by federal law. For these reasons, the text of EMTALA conclusively shows that it does not require hospitals to perform abortions. You're so full of shit. For those who find it appropriate to look beyond statutory text, in context in which EMTALA was enacted, reinforces the text makes clear Congress designed EMTALA to solve a particular problem, preventing private hospitals from turning away patients who are unable to pay for medical care. Yada, yada, yada. It is also telling that Congress has initially enacted EMTALA in 86 and amended it once in 89. Passed appropriation riders under the Hyde Amendment to prevent federal funds from facilitating abortions except in limited circumstances. The Hyde Amendment contained only one exception for abortions necessary to save the life of the pregnant woman. Blah, blah, blah. The Hyde Amendment, an overview, blah, blah, blah. The Hyde Amendment just prevented parental funds. Hyde Amendment has changed from time to time. Sometimes it included rape, sometimes it didn't. So you're being an idiot here too, Alito. The government's reading of EMTALA is doubly strange, given that the president who signed that law repeatedly promised not to use federal funds to subsidize or require the provision of abortions. Less than 3 months before signing EMTALA, Ronald Reagan told participants in the March for Life that the resources of government are not to be used to promote or perform abortions. The American Presidency Project remarks to participants of the March for Life. Next year, he touted his administration's work to restrict the use of federal funds to perform abortions. Nobody's saying that federal funds have to be used to perform abortions. We're just saying that if you take federal funds, you have to follow these rules, which includes abortions in emergency cases. Desperate to find some crumb of support for its interpretation, the government scrapes together a handful of sources that says evidence a general understanding that EMTALA requires hospitals to perform health-related abortions prohibited by Idaho law. None of these sources stands for that proposition. First, the government searched a vast database of agencies' enforcement decisions, blah, blah, blah. The government also seizes upon provision of the Affordable Care Act, saying nothing in this act shall be construed to relieve any healthcare provider from providing emergency services as required by state or federal law, including EMTALA, because this provision was placed in a section of the act concerning abortion, the government infers that it reflects a congressional understanding that EMTALA sometimes requires abortions. Laws don't exist in a vacuum, my friend, but still, again, just because the law doesn't mention abortion, it doesn't mean that abortion is not required. I need to skip some of this or I'm going to get a headache. First, consider the requirement that EMTALA speak unambiguously. Even if it were possible to read EMTALA as requiring abortions prohibited by Idaho law, it is beyond dispute that such a requirement is not unambiguously clear. It is clear! You're just an idiot! You're a freaking idiot and you don't understand words. The statute does not mention abortion, let alone expressly bind hospitals. You're such a fool. He is so dumb. He's so dumb. Let's just look up EMTALA text. We'll come back to the comments in a second. Here we go. We're back to EMTALA. In case of a hospital, medical emergency department, an individual, whatever, blah, blah, blah. Let's see. Necessary stabilizer treatment for emergency medical conditions and labor. In general, if any individual, whether or not eligible for benefits under the subchapter, comes into a hospital and the hospital determines the individual has an emergency medical condition, the hospital must provide either within the staff and facilities available at the hospital for such further medical conditions. Let's move this over here. So the staff has to do it or transfer. Refusal to consent for treatment. A hospital is deemed to meet the requirements of 1A with respect to an individual if the hospital offers vertical medical examination and the patient, I guess, denies it. Refusal or consent to transfer. A hospital is deemed to meet the requirements with respect to an individual if the hospital offers to transfer the individual. So here's the thing. They're mentioning individual because the individual is the person, is the patient who, because the fetus wouldn't be able to deny any of these things. Let's see. Transfer, enforcement, civil money, blah, 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 civil enforcement, consultation. So in this section, emergency medical condition means a medical condition manifesting itself by acute symptoms of sufficiently severity, including severe pain, such that the absence of immediate medical attention could reasonably be expected to result in 1. Placing the health of an individual or with respect to a pregnant woman, the health of the pregnant woman or her unborn child in serious jeopardy. 2, serious impairment to bodily functions, or 3, serious dysfunction to any bodily organ or part. So they don't need to mention abortion specifically because the condition that would be required to treat such condition would be I'm having a problem with my pregnancy that's going to harm me. Somebody goes in there, they're pregnant, something in the pregnancy is going to harm the patient. That is an emergency medical condition. Say term participating hospital. Participating hospital may not delay provision and an appropriate medical screening examination required. Let's see, blah, 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 blah. Let's kind of roll back. Let's see. The term to stabilize means, with respect to an emergency medical condition described in paragraph 1A, to provide such medical treatment of the condition as may be necessary to assure, within a reasonable medical probability, that no medical deterioration of the condition is likely to result from or occur during the transfer of the individual from the facility with respect to emergency medical condition, to deliver whatever described in paragraph 1b, to deliver including the placenta. The term stabilized means with respect to an emergency medical condition described in paragraph 1a that no material deterioration of the condition is likely within reasonable medical probability to result from or occur during the transfer of the individual from the facility, or with respect to an emergency medical condition described in paragraph 1b that the woman has delivered, including the placenta. So, again, you have to stabilize. The person has to be stabilized. You have to treat the person. It would be stupid. It would be mind-numbingly stupid if we required that EMTALA list every condition that could possibly be treated and every way in which you would treat that condition that would be required under EMTALA. That would be the dumbest thing in the world. Why? Because what if you missed one? What if, in their grand wisdom, Congress was like, we're going to enumerate every single possibility. And then all of a sudden, at the end of the day, they pass the law, it gets signed by the president, and all of a sudden, somebody's in the middle of an emergency room, and somebody goes, oh, this one's not listed. We can't do this one to save this patient's health. It's not required of us. Or what if the hospital is able to say, we're not required to do this procedure? That's the even worse thing. In any condition, the hospital can look and the insurance company can look and say, oh, here's the list of all of the things that we're required to do. To treat your condition, it's not on that list. So therefore, we're not required to do it. That would be the dumbest thing in the world. But that's what Alito was saying that this law would have to do in order for it to be unambiguous. It's not, it has to be unambiguous. No, you dummy. You don't list all of the possible conditions and all the possible treatments. You list the general condition that the patient has to be in, and then you list what state the patient has to be in after the treatment is provided. And that's it. That's all you need. And if the condition is pregnant woman suffering from conditions of said pregnancy, and the treatment is abortion, then that's the requirement. The hospital is then required to perform that procedure. No ifs, ands, or buts. It's unambiguous. In not requiring the law to state every single possibility that could exist known to man or woman or whoever, it's still unambiguous because there's a definition of the general state in which a person must be in, and then the general state that person must be in at the end of the day, or at the end of the treatment. It's as simple as that. But Justice Alito, one of the dumbest Supreme Court members in the world that we've ever had ever, doesn't understand that. Maybe he's too busy trying to come up with an explanation as to why his wife flies flags that he doesn't know about. Second, considering the requirement that parties be given a choice before being bound by the spending clause, the government is interpreted. No, you don't have a choice. No, the spending clause is in the Constitution. There's no choice. You're a state of the United States of America, and as such, you're bound by the requirements of the Constitution. Somebody who's on the Supreme Court of the United States should know this. There's no choice there. They made the choice when they joined the Union. That's when they made that choice. The territory of Idaho became a state, and therefore is bound by the rules of the Constitution. Did Justice Alito not watch I'm Just a Bill on Capitol Hill? I don't know. Maybe he was too old for that. I don't know. Did he not watch Schoolhouse Rock to understand how government works? Did they not cover that in your law classes, Alito? The potential implications of permitting preemption here are far-reaching. Under government's view, Congress should apparently pay doctors to perform not only medical emergency abortions, but also third trimester elective abortions or eugenic abortions. What? In what world did he come up with that? I mean, did he pull it directly out of his ass? Was it Justice Thomas's ass? Was it Gorsuch's ass? Did they reach into each other's asses and pull it out and then form it together and form a Voltron of bad opinion? In no way does that sentence make sense in the arguments that have been stated previously in this ruling that's been leaked. Now, maybe they're saying that maybe at some point in the future, government could do this too. It could condition Medicare funds on hospitals offering assisted suicide, even the vast majority of states that ban the practice. It could authorize the practice of medicine. Any doctor who accepts Medicare payments, even if he or she does not meet the state's licensing requirements. I mean, talk about manufacturing problems that are never going to exist. While the government is not troubled by the potential consequences of its preemption argument, no. They're not troubled by the consequences of its preemption argument because the so-called consequences are just fantasies living in your bizarre head. Congress was sensitive to state prerogatives. The Medicare Act in which EMTALA is situated disclaims any construction that would authorize a federal officer or employee to exercise any supervision or control over the practice of medicine in the manner in which medical services are provided. Blah, blah, blah. EMTALA's narrow preemption clause also respects core values, blah, 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 does not preempt any state or local requirement, except to the extent the requirement directly conflicts with the requirement of the section. The response to the legislature's argument, the government claims that a handful of our cases have held that spending clause statutes can preempt the laws of non-consenting states. You consented by joining the union, dummy! But those cases do not begin to settle the question at hand. Two are entirely inapostate. Inapposite? I don't know. For someone as dumb, maybe he grabbed a thesaurus on that one. I don't know. The remaining cases simply upheld the federal government's ability to prevent use of federal money for purposes other than those intended by Congress. For present purposes, it is not necessary to decide whether the legislature's theory is correct. At a minimum, however, it provides yet another reason to be wary about interpreting EMTALA to displace the core powers of non-consenting state. Non-consenting? Is this going to be the new thing? Non-consenting state? Is he just setting this up? Is he setting up the whole non-consenting state thing for something else? That's what I'm concerned about here. One of the things that he's bringing up non-consenting states as a novel argument for, something that's going to come later. In sum, the government's new interpretation of EMTALA, it's not new, is refuted by statutory text. It's not. The context in which the law was enacted, it doesn't. And the rules of interpretation that we apply to spending clause legislation. We should reject the government's interpretation and put them out at rest. Even if the court is unwilling to decide a statutory interpretation, there is no excuse for vacating the stay. In order to obtain that injunction, the government was required to make a strong showing that it was likely to prevail on the merits. No! According to your colleagues, in order for the stay to exist, the state asking for the stay was required to show that it would prevail. You're just moving the goalposts now, Alito. Why then have 6 justices voted to vacate the stay? The per curiam itself provides no explanation. In separate opinions, 3 of the 6 agree with the government's interpretation, and at least that is an explanation that would make sense. As for the remaining 3, their only explanation is that the injunction will not stop Idaho from enforcing the law in a vast majority of circumstances, and that therefore Idaho cannot show that it will be irreparably harmed. The justification is patently unsound, says the person who makes patently unsound arguments. Anytime a state is enjoined by court from effectuating statutes enacted by representatives of its people, it suffers a form of irreparable injury. Maryland versus King. No, it doesn't suffer an injury if the state is trying to do something that it's not allowed to do. You're not injured by being prevented from doing something you're not allowed. My God, how is he so bad? How is he this dumb? Drinking game. Every time I ask how is Alito this dumb, or how somebody this dumb makes on the Supreme Court, there's a drinking game for you. The justices who have joined Barrett's concurrence claim the party's beliefs and oral arguments seem to have narrowed. Blah, 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 blah. All the parties continue to insist that the laws conflict. The Solicitor General argued that EMTALA's focus on pregnant women's health is broader than Idaho. In forceful terms, she told us, in Idaho, doctors have to shut their eyes to everything except death, whereas under EMTALA, a physician is supposed to think about serious threats to a pregnant woman's health. In light of the perceived conflict, the Solicitor General said it was gravely mistaken to suggest that there really isn't a difference between EMTALA and Idaho law. Here's the thing. Clearly, Alito here doesn't give a rat's ass about women's health. He's basically saying it doesn't matter if a woman would be forced to have their, her uterus permanently injured or whatever, because Idaho says it's okay. This is why conservatives cannot be allowed to gain a single inch of power in this country. No more power to conservatives. None. We cannot allow them to gain any more foothold in this country because we're going to be screwed. Project 2025, everything else that they want to do will be screwed if we let conservatives gain an inch more power. Be that if you're doing it with, additional Supreme Court seats, more seats in the House, getting the Senate back, or becoming president, or in any state or local governments. They need to be fought in every single square inch of this land. Conservatism needs to be pushed back because you end up with things like this BS. So 3 of the 6 justices in the majority also agree that there is a conflict, judging from their fiery rhetoric. A big one. I begin with the government's argument that there are numerous conditions that may inflict a pregnant woman where a doctor's immediate concern is not death. In those cases, the government explains a doctor might be worried about serious risk to the woman's health. Government telling EMTALA requires hospital to perform an abortion on demand in these circumstances. Idaho law says otherwise. On Idaho, a doctor may not perform an abortion unless the doctor is determined in good faith and medical judgment that the abortion is necessary to prevent the death. Even then, a doctor must attempt to perform an abortion in a manner that provides the best opportunity for the unborn to survive. These standards do not require a doctor to be objectively certain that the abortion is necessary to save the woman's life, nor does Idaho require that the risk of death be particularly immediate. But the fact that it's not there, that's the thing. You don't understand that if there's no clarity, that's the ambiguity. That's where it's ambiguous. Alito's sitting here trying to claim that EMTALA is ambiguous about abortion, yet he's saying that this law is unambiguous when it is. It is ambiguous. Because the doctor doesn't know if what is okay when it comes to, is this going to be a threat to the life of the patient? What happens if a doctor says, I think this patient's life is at risk because they're going to suffer from sepsis if this, miscarriage is not treated, and the government comes and goes, that wasn't good enough, you didn't follow the law, yeet. This law is ambiguous, and he's sitting there just being, I support this law. No, your hypocrisy is a conservative prerequisite. Different considerations, health versus life, may lead to different outcomes. For example, consider the situation of a woman who experienced a condition that was discussed in the briefs, PP-BROM, which is when a woman's amniotic sac breaks before the 37th week of pregnancy. Members of this court are not physicians and therefore should be wary about expressing conclusion about medical issues, but guidance provided by prominent medical institutions is sufficient to show how Idaho laws may conflict in such cases. If a woman experiences PP-ROM from the 34th or 37th week of pregnancy and does not go into labor, her physician is likely to recommend that labor be induced. In that situation, it does not appear the risk of conflict is high. On the other hand, when PP-ROM occurs earlier than that, the chances of conflict are greatly increased. If it occurs before the 34th week, she may experience conditions such as infection of the amniotic fluid, inflammation of the uterine lining, hemorrhage, or sepsis. However, life-threatening complications are not inevitable, and according to P-PROM Foundation, death is extremely rare. A physician may try to delay labor by putting the woman in bed rest and administering steroids. When P-PROM occurs before the 24th week, the potential for conflict appears to be even higher. But in that situation, it still may be possible to manage the situation until the baby can be delivered, and there's a good outcome for both mother and child, although studies have yielded different results. When P-PROM occurs occurs before the 34th week, there is a risk to the health of both women and her unborn child. In these situations, the Defense of Life Act requires doctors to consider whether performing an abortion is necessary to prevent death, because this is a subjective standard. Blah, 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 blah. According to the government experts, however, EMTALA requires a hospital to perform an abortion at the woman's request. It's not at the woman's request. It's because the woman's about to be, lose her uterus or some other issue or suffered from sepsis. Even if the woman has not yet developed an infection or other. So, Alito wants the person to have to develop an infection first before being able to be treated. How dumb is that? It's just like with me, and, not just like with me, but I can't get access to the medicine I used to have access to because my current insurance says that I don't have certain number of health. Like, I'm healthy fat. I'm just obese. I don't have high blood sugar. I don't have high blood pressure. I don't have high cholesterol. So in order for me to get the medicine that I would need to help me reduce my weight, I would need to become less healthy, i.e. I need to get high blood sugar or high blood pressure or high cholesterol. Like, Alito's argument here is basically the same thing. You have to force the patient to get sicker before you can treat? What happened to do no harm? That's the oath that the doctors say. The doctors take an oath, do no harm. Standing by and allowing somebody to get sicker before you can treat them is absolutely doing harm. You're doing harm by inaction, and the state of Idaho requires the doctors to do harm to their patients in contradiction of the oaths that they take as medical professionals, and in contradiction to the federal law that says you must treat these conditions. But Alito's going to be like, oh, well, they haven't gotten infected yet. Good! Treat them before they get infected, you dumb piece of crap. The gap between the Idaho law and government's interpretation matters. Idaho has always permitted abortions that are necessary to preserve the life of a pregnant woman. But you're going to force them to get infected before you can actually have a treatment, right, Alito? Dr. Alito? Man, can you imagine if Alito, instead of becoming a lawyer, decided to become a doctor instead? He would probably have patients dying on his table left and right. Now I've turned to Idaho's claim that government's reading of EMTALA would authorize abortions for mental health reasons. My colleagues dismissed the concern. For example, in the 10th week of gestation, a woman experiences serious depression due to her pregnancy. If she asks emergency medical professionals for treatment, her medical providers might conclude that her continued pregnancy could reasonably be expected to be seriously jeopardize the woman's mental health. Under the government's reading of EMTALA, the woman would then have the right to make an informed decision about the treatment she received. If the woman preferred to abort rather than manage her depression, it's not apparent why the government's reading of EMTALA would not require the abortion. Because you don't know how to read. And because this nation has a history of not treating conditions, that are mental health conditions as if they're health conditions. Just look at the history of this country and how we treat health conditions. We have seen where rule permitting abortions to protect psychological health may lead in Roe. The court held that a woman had the right to obtain post-viability abortions that was deemed necessary in appropriate medical judgment, blah, 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 blah. But you overturned Roe. Roe's no longer relevant. Don't bring up Roe. You did it. You yeeted it. Roe's no longer relevant. Don't bring up old judicial precedent that's no longer viable. You aborted Roe. Today's decision is puzzling because you're a dumbass. Having taken the unusual step of granting cert before Idaho's appeal could be heard by the 9th, the court decides it doesn't want to tackle this case after all and returns it to the 9th, which will have to decide the issue that this court now ducks. What is more, the court vacates the stay, blah, blah, blah. I cannot endorse this turn of events and therefore respectfully dissent. Respectfully, yeah.